Imagine waiting years, passing background checks, learning civics, and taking the oath of allegiance, only to be told years later that the citizenship you earned could be taken away. Today, we're breaking down why denaturalization is back in the headlines, how it can happen, and practical steps you can take to protect yourself and your family. This video focuses on policies and legal pathways that have been emphasized in enforcement priorities and campaign rhetoric, especially under the banner of fraud prevention and national security. Our goal is simple: give you clear, practical information so you understand the risks, the process, and your rights. Number 1. The hook. Why this matters right now. Citizenship is supposed to be permanent. For naturalized Americans, it's the finish line after a long journey. But denaturalization, revoking citizenship after it's been granted, challenges that idea. Even if it's statistically rare, the fear it creates is real. If you're a naturalized citizen, a green card holder on the path to naturalization, or the family member of someone who is, this is information you cannot afford to skip. Number 2. Definitions. What is denaturalization? Denaturalization is a legal process where the U.S. government seeks to cancel a person's citizenship after it's been granted. It typically happens through a civil lawsuit in federal court. If the government proves that citizenship was illegally procured or obtained by concealment of a material fact or by willful misrepresentation, a judge can revoke it. In some limited scenarios, criminal charges related to naturalization fraud may also be filed, but most denaturalization proceedings are civil, not criminal. Number 3. Why it's in the spotlight. Enforcement waves and political messaging periodically bring denaturalization back into public view. Authorities emphasize protecting the integrity of citizenship and citizenship records. Critics warn it can chill lawful immigration and make even longtime citizens feel conditional. Whatever your view, it's smart to know how the process works and where real risks exist. Number 4. Grounds for denaturalization, plain English. Let's translate the legal language into everyday terms. These are common grounds the government may rely on. 1. Fraud or misrepresentation. If you lied, omitted, or misrepresented important facts during your immigration journey. Visa, asylum, green card, or naturalization, your citizenship can be challenged later. Material means the fact would have mattered to the decision maker. 2. Illegal procurement. If you didn't actually meet the legal requirements at the time of naturalization, even if a mistake slipped through, you could be at risk. This includes problems like not having the required period of continuous residence, lacking good moral character during the statutory period, or failing specific eligibility criteria. 3. Certain unlawful activities. While rare, cases involving national security, human rights abuses, or serious crimes connected to immigration benefits can trigger denaturalization actions, especially if tied to fraud or concealment. 4. Identity issues. Using multiple identities, name variations, or prior undisclosed orders, if proven, can be used to argue that the original grant of citizenship should never have happened. Number 5. What will not automatically cost you citizenship? There's a lot of fear-mongering out there. Here are examples that, by themselves, typically do not cause denaturalization. Simple policy disagreements or political speech. Ordinary mistakes that are not material and not willful. A lawful dual citizenship in another country, unless accompanied by separate grounds. Routine travel to your birth country. Changing your name legally after naturalization, as long as you follow the rules. Context matters. An innocent error isn't the same as deliberate fraud. Still, if you're worried about a specific issue in your record, speak with a qualified immigration attorney early rather than late. Number 6. Step by step. How a case can start. Here's a simplified version of how many denaturalization cases unfold. Step 1. Screening and flagging. Databases are compared for mismatches, biometrics, prior immigration records, or undisclosed criminal histories. Step 2. Investigation. Agencies review old applications, interviews, and travel or criminal records. They may contact you or people connected to your case. Step 3. Referral to government lawyers. If they believe they have a strong case, they file a civil lawsuit in federal court to revoke citizenship. Step 4. Court process. You're served with the complaint. You can defend yourself, present evidence, and challenge the government's claims. Step 5. Decision and consequences. If a judge revokes citizenship, your naturalization is treated as if it never happened. That can trigger loss of the U.S. passport and potential removal proceedings, depending on your prior status and the facts of the case. Number 7. Who is most at risk of being scrutinized? While anyone can be investigated, practical risk tends to be higher for people whose immigration path included complex histories, like prior asylum claims, name or identity discrepancies, old removal orders, or criminal issues. Marriage-based and family-based applicants can also be scrutinized if the underlying relationship history looks inconsistent or poorly documented. None of this means you did anything wrong. It just means keep records, stay organized, and consult professionals when something seems off. Number 8. Common red flags in the record. Consider these warning signs that often attract attention. Undisclosed aliases or prior applications under another identity. Prior deportation or voluntary departure orders left unresolved. Inconsistencies across visa, asylum, green card, and naturalization forms. Claims of persecution contradicted by frequent, unexplained travel back to the country of claimed harm. Criminal arrests or convictions not listed on forms. Marital history that conflicts with dates claimed for cohabitation or good faith marriage evidence. Number 9. Paperwork power. Build your own defense file. You can't control an investigation, but you can control your readiness. Build a simple binder or digital folder containing copies of every form you ever filed: visa petitions, asylum applications, green card forms, naturalization application, etc. USCIS receipts and approval notices, copies of passports and travel records, entry/exit stamps, I-94s. Court records showing dispositions of any criminal charges, including dismissals. Marriage and divorce documents, affidavits of support, and proof of cohabitation where applicable. Proof of taxes filed during the statutory periods. Any correspondence with immigration agencies and courts. If something looks inconsistent, label it, gather context, and ask a lawyer how to present it accurately if it ever becomes relevant. Number 10. Myths versus facts. Myth: any traffic ticket can get me denaturalized. Fact: minor citations are not the same as material misrepresentation or illegal procurement. Myth: speaking your mind online can cost you citizenship. Fact: political speech is protected. The issue is fraud, eligibility, or serious unlawful conduct. Myth: if I keep a low profile, I'm safe. Fact: risk comes from record inconsistencies, not visibility. Be accurate, be documented. Myth: if I'm denaturalized, I automatically become a green card holder again. Fact: not necessarily. Outcomes depend on your prior status and case specifics. Number 11. Storytelling. 2 hypothetical scenarios. Scenario A. The overlooked date. A naturalized citizen applied for green card status years ago amid a complex family situation. On one form, a marriage date was off by 2 months. On another, the date matched the certificate. Years later, an officer notices the mismatch. Is it fraud? Not necessarily. If the mistake was not willful and not material to eligibility, it may not be grounds for denaturalization, but you need records and a credible explanation, ideally supported by documents. Scenario B. The unlisted arrest. A decade-old misdemeanor was dismissed, and the applicant forgot to list it on the naturalization form. If the omission was careless rather than deliberate, and the incident wouldn't have affected eligibility, your lawyer may argue it isn't material. Again, documentation is everything. Certified court records, dates, and proof of the dismissal. Number 12. If the government contacts you. If you get a call, letter, or visit from investigators or attorneys, do not panic and do not guess answers. Ask for communications in writing. You generally have the right to consult counsel before responding. Keep a log of who contacted you, when, and what they requested. Provide copies, not originals, unless your lawyer advises otherwise. Do not destroy or alter documents. That can turn a small issue into a major one. Number 13. Protecting your family. If your citizenship is questioned, ask your lawyer how it could affect your spouse and children. Children may have acquired citizenship through you automatically. A denaturalization order can raise complex questions about derivative citizenship and prior status. Don't assume. Get tailored legal advice for each family member. Here's your quick checklist. Build your records binder or digital folder this week. Write a one-page timeline of your immigration history. If you see a red flag, book a consultation with the reputable immigration attorney. Share this video with someone who needs peace of mind today. Thanks for watching. If you found this helpful, like the video, subscribe for more explainers, and hit the bell so you don't miss updates. In the comments, tell us what topic you want us to unpack next: citizenship mistakes to avoid, interview prep, or how to request your old records. Stay informed, stay prepared, and take care of each other.